Welcome to your exam prep review for the California Life Accident and Sickness Insurance exam. We mirror the real exam with every question, then break down the right answer, the wrong ones, and the theory behind it. Here's what we'll cover from Section 1. General insurance. Insurance and risk defined. Pure versus speculative risk. Perils and hazards. Indemnity and utmost good faith. Underwriting and adverse selection. Our website provides free exam guides and practice questions to help you ace this test. Just check out the link below and you'll find everything you need to study smarter, not harder. With the right resources at your fingertips, you'll walk into your exam feeling confident, well prepared, and ready to succeed from start to finish. Alright, let's dive in. Question 1. Under the California Insurance Code, insurance is a contract in which one party agrees to indemnify another against loss, damage, or liability arising from which kind of event. Your options are A contingent or unknown event, B, a certain and scheduled event, C, an event producing a guaranteed gain, D, a past event known to both parties. Which one is it? Pause the video if you need more time. The correct answer is A, a contingent or unknown event. A is correct because the California Insurance Code defines insurance as a contract to indemnify another against loss from a contingent or unknown event. So the trigger must be uncertain in whether or when it happens. B is wrong because a certain scheduled event carries no uncertainty, and without uncertainty there is no risk for an insurer to assume. C is wrong because the chance of a guaranteed gain describes speculative risk, which insurance never covers. Insurance restores a loss rather than creating profit. D is wrong because an event already known to both parties is no longer contingent or unknown, leaving nothing uncertain to insure under the statute. At its legal core, insurance is just a contract. One party pays a premium, and the other promises to indemnify against loss from a contingent or unknown event. Every policy, no matter how complex, reduces to that single sentence. The weight of the definition rests on two words, contingent and unknown. Contingent means the event may or may not happen at all. Unknown means even if something must happen eventually, its timing or size can't be fixed in advance. Together they describe uncertainty, the raw material insurance is built from. This is why certainty kills insurability. A scheduled, fully calculable loss isn't a risk to pull, it's just a known expense. A guaranteed gain is speculation, not indemnity. And an event already known to both parties, like a building that has already burned, leaves no contingency left to sell. Picture a bakery owner buying a policy against a future kitchen fire. On the day of signing, no one knows whether a fire will start or when or how badly. That standing uncertainty is what makes it insurance rather than a bet, and it's why buying coverage after the fire already happened would insure nothing at all. Premiums, pooling, and the promise to indemnify all depend on the outcome being unsettled at the start. That single idea underlies every later topic in the course. Question 2. In insurance, the uncertainty about whether a loss will occur is the definition of which of the following terms? Your options are A, peril, B, hazard, C, risk, D, exposure. Take a second. At which answer would you pick? The correct answer is C, risk. C is correct because risk is defined as uncertainty about whether a loss will occur. That uncertainty is the foundation of insurance, since coverage exists only to handle events that may or may not happen. A is wrong because a peril is the actual cause of a loss, such as fire or sickness, not the uncertainty surrounding whether a loss happens. B is wrong because a hazard is a condition that increases the chance or severity of a loss. It influences risk, but is not the definition of risk. D is wrong because exposure refers to the possibility or amount of loss an insurer faces, which is a separate idea from the uncertainty itself. In insurance, risk has one precise meaning: the uncertainty about whether a loss will occur. Not the loss, not its cause, not the damage, just the not knowing. That narrow definition is the foundation for everything else in the subject. An insurer can't sell certainty and can't sell impossibility. It sells relief from the in-between state where a loss is possible but not guaranteed. Where there's no uncertainty, there's no risk and nothing for a policy to attach to. 3 neighbors get folded into risk by mistake. Peril is the actual cause of loss, like fire or theft. Hazard is a condition that makes a peril more likely or severe, like a slick floor. Exposure is the possibility or amount of loss an insurer faces. Risk is none of these. It's the pure uncertainty about outcome. Picture a delivery driver over the coming year. The unresolved chance of a collision is the risk. The collision itself is the peril. Texting behind the wheel is the hazard. And the value of the truck and cargo is the exposure. On an exam, if the stem describes uncertainty about a loss happening, the answer is risk. If it names a cause, that's peril. If it raises the odds, that's hazard. If it's the amount at stake, that's exposure. Question 3. An investor buys shares of stock that may rise or fall in value. Which type of risk does this situation present? Your options are pure risk, B, morale risk, C, physical risk, D, speculative risk. Before I reveal it, which one do you think is right? The correct answer is D, speculative risk. D is correct because speculative risk carries the chance of a gain as well as a loss. Investing can produce profit or loss, so it is speculative and therefore not insurable. A is wrong because pure risk allows only loss or no loss with no chance of gain, which does not fit an investment that may appreciate. B is wrong because a morale risk is not a recognized risk category. Morale describes a careless attitude, not the gain or loss nature of an investment. C is wrong because physical risk is not a standard classification of risk. The relevant contrast here is between pure risk and speculative risk. Why can insurance cover a house fire but never an investment loss? The answer lies in one dividing line: whether the outcome can ever include a gain. Speculative risk is any situation with a chance of gain alongside a chance of loss. Investing, business ownership, and betting all share that upside potential, which is exactly why no insurer will touch them. Pure risk runs only from bad to neutral. Illness, premature death, theft, and liability all fit here, because there's nothing to win, only something to protect. Picture 2 people side by side. One buys a rental property hoping it appreciates, but it might lose value instead. That's speculative risk. The other just owns a home that might burn, or might not, with no version of the fire making them richer. That's pure risk. Whenever a situation lets the actor possibly come out ahead, that's speculative risk. Insurance only prices and pools the misfortunes nobody wants. Question 4. A kitchen fire damages an insured's home in Fresno. In insurance terms, the fire itself is best described as which of the following? Your options are A, the hazard, B, the peril, C, the risk, D, the exposure. What's your answer? Commit to one before I continue. The correct answer is B, the peril. B is correct because a peril is the cause of a loss. The fire is what actually produced the damage, so the fire is the peril the policy insures against. A is wrong because a hazard only increases the chance or severity of a loss. The fire did not raise the odds of harm, it directly caused it. C is wrong because risk is the uncertainty about whether a loss will happen, not the specific event that brought the loss about. D is wrong because exposure describes the possibility of loss being present. while the fire is the realized cause of the actual damage. Let's zoom in on the peril itself. A peril is the cause of a loss, the specific event that does the damage, like fire, theft, windstorm, or illness. Insurance policies are built around perils. Named peril coverage lists exactly what's covered, while open peril coverage covers everything except stated exclusions either way. An adjuster starts by identifying the peril, because that determines whether the policy responds at all. Peril travels with three lookalikes. Risk is the uncertainty about whether a loss will happen. Hazard is a condition that raises the chance or severity of loss. And exposure is the value at stake if loss occurs. Picture that Fresno kitchen again. The morning uncertainty was the risk. The towel left on a hot burner was the hazard. The flames themselves were the peril. And the kitchen's replacement value was the exposure the insurer accepted. So on the exam, ask one clean question. Did this thing cause the damage? Or did it just make the damage more likely? The one that actually did the damage is always the peril. Question 5. Anything that increases the likelihood or severity of a loss, without itself being the cause of the loss, is known as which of the following? Your options are A hazard, B, a peril, C, a pure risk, D, an exposure unit. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A, a hazard. A is correct because a hazard is any condition that increases the chance or severity of a loss. It does not cause the loss itself, but tips the odds toward a peril striking. B is wrong because a peril is the direct cause of a loss, such as illness or fire, whereas a hazard merely makes that cause more likely. C is wrong because pure risk describes a situation offering only loss or no loss. It is a type of risk, not a condition that raises loss probability. D is wrong because an exposure unit is the measure of risk an insurer assumes for rating, which is unrelated to increasing the chance of a loss. Some conditions in a loss never cause the harm and never suffer it, but they quietly control how often harm strikes and how bad it gets. That in-between role is the hazard, a condition that raises the likelihood or severity of a loss without being the cause itself. Hazards come in three recognized kinds. A physical hazard is a tangible condition, like an icy walkway or a heart condition. A moral hazard is dishonesty of character, like faking a claim. A morale hazard is carelessness that grows because insurance exists, like leaving doors unlocked because a policy will pay. Picture two identical houses. One keeps a dry brush pile against the back wall all summer. The other keeps the yard clear. Neither pile nor clear yard is a fire, but if a spark lands, the brush feeds a bigger blaze. That's the hazard loading the dice, while the fire itself is the peril. A reliable check. Ask whether removing the item would prevent the loss outright or merely lower its odds. If it only lowers the odds, it's a hazard, not the peril, and it's not the same as risk, which is just the plain uncertainty of outcome. Underwriting lives almost entirely in finding and pricing these hazards before saying yes. Question 6. An applicant has a documented heart condition confirmed by medical tests. For underwriting purposes, this condition is best classified as which type of hazard? Your options are A, moral hazard, B, moral hazard, C, speculative hazard, D, physical hazard. Which would you go with? Lock it in before the reveal. The correct answer is D, physical hazard. D is correct because a physical hazard is a tangible, identifiable bodily or environmental condition that increases the chance of loss. A diagnosed heart condition is exactly such a measurable physical condition. A is wrong because a moral hazard stems from dishonesty or character, such as faking a claim, not from a genuine medical condition the applicant actually has. B is wrong because a moral hazard reflects carelessness or indifference because insurance exists. A documented illness is a physical fact, not an attitude. C is wrong because speculative hazard is not a recognized category. The heart condition is a measurable physical impairment, which underwriters treat as a physical hazard. When an applicant walks in with a heart condition confirmed by medical tests, that fact belongs to a specific category underwriters call physical hazard. A physical hazard is any concrete documented condition of a body, object, or environment. In life and health terms, that means things like blood pressure, weight, a chronic diagnosis, a hazardous occupation, or a dangerous hobby. The exam loves to blur physical hazard with moral and moral hazard, since all three raise the odds of loss. Physical hazard comes from a real bodily or environmental fact. Moral hazard comes from dishonesty. And moral hazard comes from a careless attitude that shows up simply because coverage exists. Picture the same heart patient in two frames. Disclosed honestly, it is a physical hazard rated properly, hidden to win a lower price. That same physical hazard now has a moral hazard layered on top. The phrase to catch on the exam is a tangible, documented, bodily or environmental condition, especially a medical diagnosis confirmed by tests. Facts, unlike attitudes, are exactly what underwriting is built to measure and price. Question 7. An applicant deliberately conceals a known heart condition on a health application to obtain coverage. This dishonest conduct is best classified as which type of hazard? Your options are A. Physical hazard, B. A moral hazard, C. Moral hazard, D. Speculative hazard. Don't overthink it, which one feels right? The correct answer is C. Moral hazard. C is correct because a moral hazard arises from a person's dishonesty or character, such as lying on an application to gain coverage. The deliberate deceit is what makes this moral rather than merely careless. A is wrong because a physical hazard is a tangible bodily or environmental condition, like the heart condition itself, not the choice to hide it. B is wrong because a moral hazard reflects carelessness or indifference once insured, while concealing a condition is an intentional act of deception. D is wrong because speculative risk involves a chance of gain or loss and is not a hazard category, so the label cannot apply here. Not every risk to an insurance pool is physical. When someone deliberately hides a health condition to get coverage, they introduce a moral hazard, increased loss potential rooted in dishonesty, not in any measurable fact about the world. Moral hazard shows up in a few classic forms: lying on an application, staging or exaggerating a claim, and destroying insured property on purpose to collect. The common thread is deliberate deceit, a hidden intention no inspection can catch. The exam loves this distinction. Moral hazard is active dishonesty, the deliberate choice to deceive. Moral hazard is passive carelessness, like the driver who stops locking an insured car. Physical hazard is just a measurable condition. Watch for words like deliberate, conceal, misrepresent, and fraud. Picture two applicants with the exact same heart condition. One discloses it honestly and gets priced fairly. The other buries the diagnosis to steal a rate, never meant for that risk. Same disease, but concealment layers a moral hazard on top. Insurance runs on trust it cannot fully verify, so moral hazard is ultimately a tax the dishonest impose on the honest. Remember, it's the concealment, not the illness, that makes it moral. Question 8. The principle that the larger the group of similar exposure units, the more accurately future losses can be predicted, is known as which of the following? Your options are A. The law of large numbers, B. The principle of indemnity, C. The law of agency, D. Adverse selection. Got a guess? Lock it in. The correct answer is A. The law of large numbers. A is correct because the law of large numbers holds that a larger pool of similar exposure units lets the insurer predict total losses more accurately, which is what makes sound pricing possible. B is wrong because the principle of indemnity restores an insured to the pre-loss financial position. It governs how claims are paid, not how losses are predicted. C is wrong because the law of agency defines how a producer represents an insurer, a relationship concept unrelated to predicting losses across a group. D is wrong because adverse selection is the tendency of poorer risks to seek coverage, a problem underwriting solves rather than a forecasting principle. The entire promise of insurance rests on one convenient piece of math. Individual events that are wildly unpredictable become highly predictable in bulk. One coin flip tells you almost nothing, but 10,000 flips land very close to half heads. No underwriter can say whether one healthy 40-year-old will die this year, but across 100,000 similar lives, that number becomes remarkably stable and predictable years in advance. That predictability at scale is what lets a company set a premium today for losses that haven't happened yet. Volume alone is not enough. The exposure units must be alike in the risk they present. Pooling wildly different ages and habits together just produces a blurry average, which is why underwriting sorts applicants into classes before this law can do its work. The exam surrounds this idea with 3 lookalikes that answer different questions. Indemnity governs how much a claim pays. Agency defines how a producer represents an insurer. And adverse selection describes bad risks crowding into a plan. Only the law of large numbers is about predicting total losses across a pool. This law is what converts uncertainty about individuals into confidence about groups. Without it, sound pricing and insurance itself would be impossible. Question 9. A wage earner faces the possibility of losing income if a disabling injury occurs, even in years when no injury happens. This ongoing possibility is best described as which of the following? Your options are a realized loss, B, an earned premium, C, a peril, D, a loss exposure. Which one is it? Pause the video if you need more time. The correct answer is D, a loss exposure. D is correct because a loss exposure is any situation that presents the possibility of a loss, whether or not a loss ever occurs. The wage earner is exposed to disability every working day. A is wrong because a realized loss is an actual reduction in value that has already happened, but here no injury or income loss has yet occurred. B is wrong because earned premium is the portion of premium an insurer has already provided coverage for, which has nothing to do with the chance of injury. C is wrong because a peril is the cause of a loss, such as the injury itself, rather than the standing possibility that such a loss could occur. A worker can go a whole career without ever getting hurt, and still carry something insurers care about every single day, a loss exposure. That's not the injury and not the lost paycheck. It's the standing possibility that harm could happen. Insurance is priced against that possibility, not against losses that have already landed. Every workday carries the quiet, continuous chance that income could be cut off, whether the bad event is near, far likely or unlikely. Precision matters because loss exposure keeps company with 3 other terms. A peril is the specific cause of a loss, like the injury itself. A realized loss is harm that has already happened. Earned premium is just the slice of premium the insurer has already provided coverage for. Picture the wage earner across 10 injury-free years. The exposure is fully real in every one of them, even with nothing gone wrong. In year 11, a fall finally happens, wages stop, and that exposure matures into a realized loss the policy responds to. On the exam, the phrase that signals loss exposure is the possibility of a loss that exists whether or not a loss ever occurs. Insurance sells protection against that potential, which is exactly why coverage has value in every quiet year nothing goes wrong. Question 10. A consumer purchases a health insurance policy to shift the financial consequences of a possible illness to an insurer. Which risk management technique does this represent? Your options are A. Risk avoidance, B. Risk transfer, C. Risk retention, D. Risk reduction. Take a second. Which answer would you pick? The correct answer is B. Risk transfer. B is correct because buying insurance is the classic example of risk transfer because the financial consequences of a covered loss are shifted from the individual to the insurer for a premium. A is wrong because avoidance means eliminating the risk by not engaging in the activity at all, but the consumer cannot avoid the chance of illness this way. C is wrong because retention means keeping the risk and paying for any loss out of pocket, which is the opposite of buying coverage from an insurer. D is wrong because reduction lowers the chance or severity of a loss through loss control, while a policy instead pays for the loss after it occurs. Buying insurance is one specific move for handling risk, formerly called risk transfer. It means shifting the financial consequences of a possible loss onto an insurer in exchange for a premium. The risk itself never disappears when you buy a policy. What changes is who pays if disaster strikes. Some losses, like a serious illness, are too large for one person to absorb, but manageable for an insurer's pool. So transfer trades an unpredictable catastrophe for a small predictable cost. There are 4 ways to handle risk. Avoidance eliminates the risk by not engaging in the activity at all. Retention means keeping the risk and paying losses yourself. Reduction lowers the chance or severity of a loss, like exercising or installing smoke detectors. Transfer is different. The risk stays possible, but its financial sting passes to an insurer. The exam loves testing transfer against retention and reduction, since all 3 leave the risk technically in existence. The separating question is simple. Who pays if the loss happens? Under transfer, the insurer pays. Under retention, the individual pays. And under reduction, the loss is merely less likely, with no one arranged to cover it. Watch for the phrase, shifting the financial consequences of a loss to an insurer for a premium. That's transfer. And buying insurance is its textbook example. Transfer doesn't erase risk. It relocates the cost of it. And that relocation is exactly what an insurance policy sells. Question 11. A person decides never to go scuba diving so that the chance of a diving injury is eliminated entirely. Which risk management technique does this choice illustrate? Your options are A. Risk reduction, B. Risk retention, C. Risk avoidance, D. Risk transfer. Before I reveal it, which one do you think is right? The correct answer is C. Risk avoidance. C is correct because risk avoidance eliminates a risk completely by choosing not to engage in the activity that creates it. Refusing to dive at all removes that injury exposure entirely. A is wrong because reduction would mean still diving but taking safety steps to lower the chance or severity of injury, not declining the activity outright. B is wrong because retention means accepting the risk and bearing any resulting loss yourself, whereas this person removes the exposure rather than keeping it. D is wrong because transfer shifts the financial risk to an insurer for a premium, but here the person eliminates the activity instead of insuring it. A person who resolves never to go scuba diving has done something no insurance policy can match. Erase the risk of a diving injury completely, because the exposure itself is gone. Avoidance stands apart from every other risk management technique because it alone drives the probability of loss to 0. Every other approach leaves the risk alive in some form. Avoidance simply removes the person from the situation. The catch is that avoidance is often impossible or impractical, which is exactly why insurance exists. A person can skip scuba diving without much sacrifice, but no one can avoid illness, aging, or death. And few can avoid driving or owning a home. Where the risk is essential to ordinary life, avoidance is off the table. Set side by side, the four techniques snap into focus. Refusing to dive is avoidance. Diving with a certified partner and inspected equipment is reduction. Accepting that any injury comes out of one's own savings is retention. And buying a policy that covers diving injuries is transfer. Only avoidance removes the possibility of loss outright. On the exam, words like eliminate, never, refuse, and do not engage signal avoidance. Remember, it's the cleanest solution and the least available one, which is why the whole insurance industry exists, to serve the risks nobody can simply walk away from. Question 12. Most insurance policies exclude losses caused by war. The exclusion exists because covering war would violate which requisite of an ideally insurable risk? Your options are: A. The loss must be non-catastrophic. B. The loss must be accidental. C. The loss must be measurable. D. The premium must be affordable. What's your answer? Commit to one before I continue. The correct answer is A. The loss must be non-catastrophic. A is correct because an ideally insurable risk must be non-catastrophic, meaning the loss cannot strike a huge number of insureds at once. War would cause massive simultaneous losses, so it is excluded. B is wrong because the accidental requisite asks that a loss be due to chance and outside the insured's control, which is a different reason from war's catastrophic scale. C is wrong because the measurable requisite requires that a loss be definite in time, place, and dollar amount, a concern unrelated to the sheer volume of war losses. D is wrong because affordability addresses whether premiums are economically feasible, not whether a single event could produce overwhelming simultaneous claims. Not every real risk can be insured. To qualify for private insurance, a risk must meet several conditions, and one of the most important is that its losses stay non-catastrophic, meaning they won't strike huge numbers of people all at once. An ideally insurable risk must be accidental, measurable, spread across a large number of similar units, economically feasible to insure, and non-catastrophic. Each condition protects a different part of how insurance actually works. Insurance depends on independence. One person's misfortune shouldn't be linked to the next person's, so only a small, predictable fraction of the pool files claims. A catastrophe shatters that independence, making everyone claim together. Picture a life insurer with 100,000 policies across a country at war. In peacetime, deaths trickle in steadily, exactly as premiums were built to cover. But in wartime, a single battle can kill thousands of insureds in one afternoon, all filing at once. War isn't excluded for being intentional, hard to measure, or unaffordable. It's excluded because it's catastrophic, capable of striking the whole pool at once. Watch for exclusions tied to mass, simultaneous loss. That's always the non-catastrophic requisite at work. Question 13. Under the California Insurance Code, a contingent or unknown event that may be insured against may relate to which of the following time frames? Your options are: A. Only future events. B. Only present events. C. Only intentional events. D. Either past or future events. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. Either past or future events. D is correct because the California Insurance Code allows insuring a contingent or unknown event, whether past or future, so long as it remains unknown to the parties at the time of contracting. A is wrong because limiting insurable events to the future is too narrow. since the statute expressly permits insuring a past event that is still unknown. B is wrong because the statute is not confined to present events. What matters is uncertainty, and that uncertainty can attach to a past or future occurrence. C is wrong because intentional events are not the test at all. An insurable event must be contingent or unknown, not deliberately brought about by the insured. Here's a surprising rule. California law allows you to insure a past event, not just a future one. What matters isn't when something happened, but whether it's still unknown to both parties when the contract is signed. The definition of insurance rests on a contingent or unknown event. Contingent naturally suggests the future, but unknown reaches backward too, covering something that already happened but hasn't been confirmed by anyone yet. Marine insurance is the historical home of this rule. A cargo owner buying coverage could not know whether a ship already out of contact was safe at sea or lost days earlier in a storm. So the law lets a past event stay insurable as long as it remains genuinely unknown. Picture a company insuring a shipment on Monday, unaware that the container was damaged the previous Friday. Since neither side knew of the loss when the contract took effect, coverage still applies. But if both parties already knew the goods were ruined, the contract fails, because there's no real risk left to transfer. The exam trap is forcing an event into only past or only future. The real rule is that a contingent or unknown event can be either so long as it stays unknown, because an unknown past can be just as insurable as an uncertain future. Question 14. For life and disability insurance under California law, when must the insurable interest exist in order for the contract to be valid? Your options are only at the time of loss, B, at the time the contract takes effect, C, continuously throughout the policy term, D, only when the claim is paid. Which would you go with? Lock it in before the reveal. The correct answer is B, at the time the contract takes effect. B is correct because for life and disability insurance, insurable interest must exist when the contract takes effect. It need not still exist at the time of loss, unlike the rule for property insurance. It is wrong because requiring the interest only at the time of loss states the property insurance rule. Life and disability instead fix the interest at policy inception. C is wrong because continuous insurable interest is not demanded, because a valid life policy may continue even after the original financial interest has ended. D is wrong because tying the interest to the moment the claim is paid misstates the law. The decisive point is when coverage begins, not when proceeds are dispersed. Insurable interest means the person buying insurance must actually stand to lose something if the covered event happens. Without it, insurance becomes a bet on someone else's misfortune, which the law won't enforce. The whole point of insurable interest is to stop insurance from becoming a wagering contract. If anyone could insure a stranger's life and collect on their death, that turns a human life into a lottery ticket and creates an incentive for harm. This is where the exam trap lives. Life and disability insurance require insurable interest only at time of issue, when the policy is written. Property insurance requires it at time of loss, since it exists to indemnify a present actual loss. Picture a spouse's life policy. The interest was real when the policy began, so a later divorce doesn't void it. Now contrast a homeowner's fire policy, where the owner must still hold that interest the moment the fire happens, because property coverage restores a loss born right then. On the exam, whenever you see life or disability insurance paired with a question about timing, lock onto time of issue. Save time of loss for property and you'll never get this backward again. Question 15. A health policy reimburses an insured for actual covered hospital charges, but pays nothing beyond those costs. Which insurance principle does this reflect? Your options are A. Utmost good faith. B. Adverse selection. C. The principle of indemnity. D. The law of large numbers. Don't overthink it. Which one feels right? The correct answer is C. The principle of indemnity. C is correct because the principle of indemnity restores an insured to the financial position held just before a loss. No better and no worse. Reimbursing owner actual covered expenses reflects this principle. A is wrong because utmost good faith concerns honesty and full disclosure between the parties, not the rule that a payout merely restores the insured's actual loss. B is wrong because adverse selection is the tendency of higher risk individuals to seek coverage, an underwriting concern unrelated to how a claim amount is measured. D is wrong because the law of large numbers explains how insurers predict total losses across a pool, which does not govern the size of an individual reimbursement. Insurance has a quiet governing rule. It restores you to where you were before the loss, no better, no worse. That ceiling, being made whole and stopping exactly there, is the entire idea of indemnity. Indemnity keeps insurance acting like a repair shop rather than a lottery ticket. If a payout could exceed the actual loss, people would have a financial reason to cause damage or exaggerate claims, and moral hazard would take over the system. In practice, this means reimbursement tracks real expenses, deductibles, co-insurance, policy limits, and insurable interest all exist to make sure the insured recovers only the genuine economic loss, never more. The exam loves to confuse indemnity with three other principles. Utmost good faith is about honesty when forming the contract. Adverse selection is about worse risks seeking coverage. And the law of large numbers is about predicting total losses across a pool. Only indemnity governs the size and measure of a payout. Remember, indemnity restores rather than rewards. Life insurance, paid as a stated amount instead of a measured loss, is the one notable exception to this rule. Question 16. An insurance contract assumes complete honesty and full disclosure of material facts by both the applicant and the insurer. This expectation reflects which principle? Your options are A. Utmost good faith, B. Indemnity, C. Reasonable expectations, D. Estoppel. Got a guess? Lock it in. The correct answer is A. Utmost good faith. A is correct because utmost good faith requires both parties to act honestly and disclose material facts. Because insurance relies on this mutual candor, concealment or misrepresentation can let the wrong party void the contract. B is wrong because indemnity addresses restoring an insured to the pre-loss financial position, not the mutual duty of honesty when forming the contract. C is wrong because reasonable expectations is a rule of interpreting ambiguous policy language, which is separate from the duty of full and honest disclosure. D is wrong because estoppel prevents a party from asserting a fact contrary to its prior conduct, a different doctrine from the shared duty of good faith. Ordinary deals run on buyer beware, where each side looks out for itself. Insurance flips that rule entirely. It is a contract of utmost good faith, demanding complete honesty and full disclosure of material facts from both sides. The standard exists because of a deep information gap. The applicant knows private health history and habits the insurer can't discover, while the insurer drafts complex terms the applicant can't verify. Without candor, the whole arrangement collapses. Picture an applicant completing a life insurance application. Utmost good faith requires disclosing a serious diagnosis truthfully, and it equally binds the insurer to fair terms and honest handling. If the applicant conceals that diagnosis, the insurer may later rescind because concealment breaks the good faith foundation the policy was priced on. The exam contrasts this with adjacent doctrines. Indemnity is about how much a claim pays. Reasonable expectations is about reading ambiguous wording, and estoppel bars a party from contradicting its own prior conduct. Only utmost good faith names the mutual duty of honesty and full disclosure. If a stem says complete honesty and full disclosure of material facts by both parties, that's utmost good faith. Nearly every disclosure rule in insurance law grows out of the single expectation of candor. Question 17. When a producer gathers accurate and complete information on an application and screens the applicant before submitting it to the insurer, the producer is acting in which role? Your options are A. Claims adjuster, B. Actuary, C. Reinsurer, D. Field underwriter. Which one is it? Pause the video if you need more time. The correct answer is D. Field underwriter. D is correct because the producer is the insurer's field underwriter, the first line of risk evaluation. Gathering accurate, complete application information and screening applicants is exactly that role. A is wrong because A claims adjuster investigates and settles losses after they occur, which happens long after the application stage the producer handles. B is wrong because an actuary uses statistics to calculate rates and reserves at the home office, not to collect individual application information in the field. C is wrong because a reinsurer accepts risk transferred from a primary insurer, a company-to-company function unrelated to taking an applicant's information. Long before an underwriter at the home office ever opens a file, the producer sitting across the kitchen table has already sized up the applicant. That producer is acting as a field underwriter, the insurer's very first line of risk evaluation. Company underwriters only ever work from documents. They never meet the applicant in person. If the producer gathers sloppy or slanted information, every decision built on top of it is compromised from the start. Doing the job well means asking complete questions, recording answers faithfully, and refusing to help an applicant paper over a problem. The producer isn't the final decision maker, but as gatekeeper, a producer who looks the other way corrupts the file at its very source. The exam separates this from other roles at different stages. A claims adjuster settles losses after they occur. An actuary calculates rates and reserves from statistics. And a reinsurer accepts risk transferred from another insurer, never touching the applicant at all. On the exam, the teller is a producer gathering complete, accurate information and screening the applicant before submission. That's the field underwriter. Everything the company decides afterward depends on how honestly that first look was done. Question 18. An underwriter assigns each applicant to a risk class. Which of the following is not one of the standard underwriting risk classifications? Your options are A. Preferred, B. Standard, C. Speculative, D. Substandard. Take a second. Which answer would you pick? The correct answer is C. Speculative. C is correct because the standard underwriting risk classifications are preferred, standard, substandard, and declined. Speculative is a type of risk, not a classification an underwriter assigns to an applicant. A is wrong because preferred is a genuine classification for better than average risks who qualify for the lowest rates, so it cannot be the exception sought. B is wrong because standard describes an average risk charged ordinary rates, which is one of the recognized underwriting classes rather than an imposter. D is wrong because substandard names a higher than average risk charged a rated premium, making it a legitimate classification and not the term that does not belong. Underwriters don't treat every applicant the same, and they aren't supposed to. Their central job is classification, sorting each applicant into a risk class that determines what coverage costs, or whether it's offered at all. There are only 4 recognized classes. Preferred applicants are healthier or safer than average and get the lowest rates. Standard applicants pay ordinary rates. Substandard applicants are charged a higher rated premium for added risk, and declined applicants are refused coverage at any price. Each rung on this ladder reflects a judgment about how an applicant's expected losses compare to the pool's average. Substandard doesn't mean uninsurable, it means insurable at a fair price. Declined is the true endpoint, reserved for risk no premium can offset. The exam's favorite trap is slipping speculative into the list of classes. Speculative is a real insurance term, but it describes a kind of risk, one involving a chance of gain, not a grade assigned to an applicant. Preferred, standard, and substandard are legitimate classes, with declined at the far end. Any term describing the nature of a risk instead of an applicant's grade is wearing a costume, and that word is usually speculative. Question 19. An insurer finds that mostly unhealthy individuals are applying for and renewing its new health plan, while healthier people decline it. This tendency is known as which of the following? Your options are A. Adverse selection, B. Profitable distribution of exposures, C. Coinsurance, D. Reinsurance. Before I reveal it, which one do you think is right? The correct answer is A. Adverse selection. A is correct because adverse selection is the tendency of higher than average risks to seek and keep coverage more than average risks. Term do. It threatens an insurer because actual losses then exceed predictions. B is wrong because a profitable distribution of exposures is the balanced spread of risks good underwriting achieves, which is the opposite of what is happening here. C is wrong because coinsurance is a cost-sharing provision splitting covered expenses between insurer and insured, unrelated to which applicants choose to buy coverage. D is wrong because reinsurance is insurance an insurer buys to limit its own exposure, not the pattern of unfavorable risk crowding into a plan. Every insurer fights the same current. The people most eager to buy and keep coverage are often the ones most likely to need it. That tendency of higher risk people to seek and retain insurance more than average risks due is called adverse selection. Picture an insurer launching a plan with light screening. The people who rush to enroll and never miss a renewal turn out to be disproportionately those already managing illness, while healthy people stay away, and within a year claims run far higher than the pricing assumed. This is why underwriting exists at all. Medical questions, waiting periods, pre-existing condition provisions, and incentives for healthy people to enroll are all defenses against the natural drift toward a sicker than average pool. Don't confuse this with related terms. A profitable distribution of exposures is the balanced pool underwriting aims for. Coinsurance splits, costs between insurer and insured. Reinsurance is insurance an insurer buys for itself. Only adverse selection names bad risk crowding into a plan. Adverse selection is the constant pull insurers must resist, and nearly every underwriting rule is a stroke against that current. Question 20. In an insurance contract, the consideration given by the applicant consists of which of the following? Your options are A. The insurer's promise to pay claims, B. The premium and statements in the application, C. A guarantee of future dividends, D. The policy's written terms. What's your answer? Commit to one before I continue. The correct answer is B. The premium and statements in the application. B is correct because the applicant's consideration is the premium payment together with the representations made in the application. The insurer's consideration, by contrast, is its promise to pay covered losses. A is wrong because the promise to pay claims is the insurer's consideration, not the applicant's. So it describes the wrong party's contribution to the bargain. C is wrong because a guarantee of future dividends is not consideration at all and is not something the applicant furnishes when entering the contract. D is wrong because the policy's written terms are the document recording the agreement, not the thing of value the applicant gives to support the contract. Every valid contract needs consideration, something of value each side gives to support the bargain. And an insurance policy is no different. The tricky part is naming exactly what the applicant contributes. Consideration is just one of the basic elements every enforceable contract shares, alongside offer and acceptance, legal purpose, and competent parties. It simply means the value each party trades to the other. The applicant's consideration is two things together, the premium payment and the statements made on the application. The insurer's side is different in kind. It's promised to pay covered losses, and that asymmetry is exactly what makes insurance contracts interesting. Picture an applicant writing a check for the first premium and signing an application answering questions about her health and history. Those two acts together are her consideration, given in exchange for the insurer's promise to indemnify her for covered losses. If she later lies materially on the application, the insurer can attack the contract, because her false answer spoiled part of the very consideration she pledged. So when the exam asks what the applicant gives, the answer is premium plus application statements, never the insurer's promise, a dividend guarantee, or the policy's written terms. Question 21. An applicant applies for coverage and the insurer responds by issuing a policy with a higher premium and an added exclusion. The insurer's response is best described as which of the following? Your options are A. An unconditional acceptance, B. A valid waiver, C. An implied warranty, D. A counteroffer. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. A counteroffer. D is correct because issuing a policy on terms different from those applied for changes the deal, so it is a counteroffer. The applicant may then accept it, often by paying the modified premium, or reject it. A is wrong because an unconditional acceptance would mirror the application exactly, but altering the premium and adding an exclusion changes the terms instead of matching them. B is wrong because a waiver is the voluntary surrender of a known right, which does not describe an insurer proposing new and different policy terms. C is wrong because an implied warranty is a promise the law reads into a contract, unrelated to whether the insurer accepted or modified the application. Applying for insurance isn't the same as being accepted for it. When an insurer responds to an application by changing the premium or adding an exclusion, it hasn't accepted the deal. It has made a counteroffer, a new proposal that rejects the original terms. Insurance contracts form through offer and acceptance must mirror the offer exactly. The applicant usually offers by submitting the application and premium. The insurer can accept, decline, or counteroffer. The instant the insurer changes the premium or adds an exclusion, the mirror is broken and no contract exists yet. Picture an applicant seeking a standard policy. The underwriter finds a risk factor and issues the policy at a higher premium with an exclusion. Nothing is in force yet. The roles have flipped, and now the insurer is the offerer, while the applicant holds the power to accept or walk away. Don't confuse a counteroffer with its lookalikes. An acceptance matches the application exactly with no changes. A waiver is the voluntary surrender of a known right. An implied warranty is a promise the law reads into the contract. Only changed terms on a new policy make it a counteroffer. Whenever an insurer responds by adding cost, tightening coverage, or attaching conditions, that's a counteroffer, and contract formation waits on the applicant's acceptance. Changed terms mean no deal yet, and the applicant gets the final word. Question 22. Because the insurer alone drafts the wording of a policy, any genuine ambiguity in that wording is generally interpreted in whose favor? Your options are A. The insurer that wrote it, B. The State Insurance Guarantee Fund, C. The insured or beneficiary, D. Neither party until a court rewrites it. Which would you go with? Lock it in before the reveal. The correct answer is C. The insured or beneficiary. C is correct because an insurance policy is a contract of adhesion drafted entirely by the insurer. Because the insured cannot negotiate the wording, courts construe genuine ambiguities against the insurer and in favor of the insured. A is wrong because ruling for the insurer would reward the very party that created the unclear language, which the adhesion doctrine specifically refuses to do. B is wrong because the guarantee fund protects policyholders only when an admitted insurer becomes insolvent and plays no role in interpreting ambiguous wording. D is wrong because courts do not refuse to decide or rewrite the contract. They resolve the ambiguity in favor of the adhering party, the insured. Insurance policies are written entirely by the insurer, and the applicant can only accept or walk away, never negotiate the wording. That take it or leave it setup makes insurance a contract of adhesion with a specific legal consequence for unclear language. Because only the insurer drafts the terms, the law refuses to let that same insurer benefit from its own vague wording. When a clause is genuinely ambiguous, courts resolve it against the drafter and in favor of the insured. The doctrine only triggers on genuine ambiguity. Wording a reasonable person could read more than one way. Clear language is enforced as written, even if that disappoints the insured, because this rule is a tiebreaker, not a rewrite tool. Picture a health policy clause that could reasonably be read to cover a treatment or to exclude it. If a court finds the wording truly ambiguous, it adopts the reading that favors the insured, since the insurer chose the words and could have written them plainly. On the exam, unclear wording in a policy the insured couldn't negotiate always resolves in favor of the insured or beneficiary. The cost of unclear drafting falls on whoever held the pen. Question 23. One insured pays a small premium, yet soon collects a far larger benefit, because the payout depends on an uncertain event. This describes which characteristic? Your options are A. Aleatory, B. Unilateral, C. Conditional, D. Personal. Don't overthink it. Which one feels right? The correct answer is A. Aleatory. A is correct because an aleatory contract is one in which the values exchange may be unequal because performance depends on an uncertain event. Insurance fits this since payout turns on whether a covered loss occurs. B is wrong because the unilateral characteristic refers to only the insurer making an enforceable promise, not to the possibility that the dollar amounts exchanged are unequal. C is wrong because the conditional characteristic means certain conditions must be met before the insurer pays, which is a different feature from the lopsided value exchange. D is wrong because the personal characteristic means the contract is made with a particular person and cannot be freely transferred, unrelated to unequal values. Two neighbors buy identical health policies the same afternoon. One collects a huge benefit within a month. The other pays for 30 years and never files a claim. Same contract, wildly unequal outcomes, and the reason is a single word, aleatory. The insured pays a fixed small premium no matter what happens. What the insurer pays back depends entirely on chance, on whether and when a covered loss occurs, so neither side knows in advance who comes out ahead. This inequality isn't a flaw, it's the mechanism. Insurance works because the many who pay and never collect fund the few who do, which is exactly the opposite of a commutative contract, where both sides intend an even exchange. The exam tests whether you can separate these traits. Unilateral is about who makes the binding promise. Conditional is about requirements like filing proof of loss, and personal is about non-transferability. Only a literary names the chance-driven, possibly lopsided exchange of value. Across the whole pool, these unequal. Chance-based exchanges balance into stable protection, even though no single policy trades equal value. That honest admission of chance is what a literary means. Question 24. An insurance policy is described as a unilateral contract because of which of the following? Your options are A. Both parties exchange enforceable promises. B. The insured must continue paying premiums. C. Only the insurer makes an enforceable promise. D. The contract can be freely assigned. Got a guess, lock it in. The correct answer is C. Only the insurer makes an enforceable promise. C is correct because an insurance contract is unilateral because only the insurer makes a legally enforceable promise to pay covered losses. The insured makes no enforceable promise and may stop paying premiums without being sued. A is wrong because an exchange of enforceable promises by both sides would make the contract bilateral, which is precisely the classification insurance does not fit. B is wrong because the insured is not legally obligated to keep paying. The freedom to stop paying without liability is what makes the contract one-sided. D is wrong because free assignability relates to the personal nature of insurance, not to the fact that only one party makes a binding promise. Why can't an insurer sue you for missing a premium payment? The answer reveals a core feature of every insurance policy. It's a unilateral contract. The insurer alone is legally bound to perform once the policy is active. The insured has promised nothing the law will compel. Paying premium simply keeps coverage alive. So stopping payment triggers a lapse, never a lawsuit. The exam distractors are precise. Two-sided enforceable promises would be bilateral. Unequal chance-based value describes aleatory. And non-transferability describes personal. None of those capture who is legally bound, which is the unilateral feature. Picture a covered loss where the insurer refuses to pay. The insured can go to court and enforce that one promise. The enforceability runs only one way, from insurer to insured, because the insured already completed their side by paying and applying. Unilateral simply counts the enforceable promises, and in insurance there's exactly one made by the company. Question 25. Under the California Insurance Code, the written instrument in which a contract of insurance is set forth is known by which term? Your options are A. The application, B. The policy, C. The rider, D. The binder. Which one is it? Pause the video if you need more time. The correct answer is B. The policy. B is correct because the California Insurance Code defines the policy as the written instrument in which a contract of insurance is set forth. The policy is the document that records the agreement. A is wrong because the application is the applicant's request for coverage and a source of representations, not the written instrument that states the contract. C is wrong because a rider is an attachment that amends the policy by adding or limiting coverage, not the core instrument setting forth the contract. D is wrong because a binder is temporary evidence of coverage issued before the policy, not the written instrument the statute defines as the policy. In everyday speech, policy means the whole insurance arrangement. But California law is much more precise. The policy is the written instrument in which a contract of insurance is set forth. It's the document itself, not the coverage in the abstract. Precision matters because insurance involves several distinct documents, and each plays a different legal role. The policy is the master instrument recording the contract, while the application, the rider, and the binder each do something else entirely. Picture the sequence. The applicant signs the application. the producer hands over a binder so coverage starts right away, and weeks later the insurer issues the policy itself, sometimes attaching a rider afterward. 4 documents, 4 separate jobs. The exam loves these lookalikes as traps. The application is just the request for coverage. The rider is an amendment that needs a policy to attach to, and the binder is only temporary stopgap evidence, not the finished writing. Remember the phrase, the written instrument in which a contract of insurance is set forth. That's the policy, and California law carefully separates it from the papers that merely request, amend, or temporarily stand in for it. Question 26. Under the California Insurance Code, the neglect to communicate something that a party knows and ought to communicate is defined as which of the following? Your options are A. Warranty, B. Estoppel, C. Concealment, D. Subrogation. Take a second. Which answer would you pick? The correct answer is C. Concealment. C is correct because the California Insurance Code defines concealment as the neglect to communicate that which a party knows and ought to communicate. Concealment is a failure to disclose, not a false statement. A is wrong because a warranty is a statement guaranteed to be true and made part of the contract, which is the opposite of a silent failure to disclose. B is wrong because estoppel bars a party from contradicting its earlier conduct, a doctrine unrelated to the failure to communicate a known material fact. D is wrong because subrogation lets an insurer recover from a responsible third party after paying a claim, which has nothing to do with non-disclosure. Lying isn't the only way to deceive an insurer. Silence can do it just as effectively. California defines concealment as the neglect to communicate what a party knows and ought to communicate. A withholding, not a false statement. The definition has 2 moving parts that must both be present. The party must know the fact, and the party must be under a duty to communicate it. Neglecting to share something unknown or something immaterial with no duty attached is not concealment. Insurance runs on disclosure the insurer cannot independently verify. When an applicant sits on a material fact, the insurer underwrites blind, pricing a risk it never actually saw. The exam contrasts concealment with lookalike doctrines. A warranty is a guaranteed statement made part of the contract. Estoppel bars contradicting one's own prior conduct. Subrogation lets an insurer recover from a third party after paying a claim. Only concealment names the neglect to communicate a known material fact. On the exam, the signal is silence about something known and material, a failure to communicate rather than a false statement. That is concealment, and California treats it as a wrong every bit as serious as a lie. Question 27. Under the California Insurance Code, which of the following need a party not communicate to the other, even when directly asked about it? Your options are A. Information of the party's own judgment, B. A known material change in health, C. A fact the insurer specifically inquires about, D. The existence of other coverage. Before I reveal it, which one do you think is right? The correct answer is A. Information of the party's own judgment. A is correct because the California Insurance Code provides that neither party must communicate information of its own judgment, even upon inquiry. Facts must be disclosed if asked, but personal opinions need not be. B is wrong because A known material change in health is a fact that must be disclosed when material, so it is not protected from communication the way opinion is. C is wrong because a fact the insurer specifically inquires about must be answered truthfully. The exceptions for volunteering information end once a direct question is asked. D is wrong because the existence of other coverage is a fact that may be material and is not shielded from disclosure simply because it concerns the applicant. California's duty to disclose an insurance is broad, but not unlimited. One carve-out stands out above the rest. Neither party must ever communicate information of its own judgment, even when directly asked. The law protects judgment because it isn't information one side has and the other lacks. A material fact, like a diagnosed illness, is concrete data. A judgment, like your private opinion about your own lifestyle risk, is just an evaluation the insurer is entitled to make itself. This exception sits inside a larger scheme of things neither party must disclose absent inquiry. What the other already knows, what they ought to know, matters they waive, and matters of law presume known equally, but judgment alone survives even a direct question. Picture a form asking an applicant's thoughts on their overall health outlook. That private opinion is judgment and stays protected. But if the same form asks whether a doctor diagnosed a specific condition, that's a fact, and it must be answered honestly. A known material fact, a change in health, a directly inquired about fact, or other coverage are all disclosable. Only information of one's own judgment escapes the duty, even on inquiry. Question 28. On most life and health insurance applications, the answers an applicant provides are generally treated under California practice as which of the following? Your options are A. Express warranties, B. Implied warranties, C. Conditions precedent, D. Representations. What's your answer? Commit to one before I continue. The correct answer is D. Representations. D is correct because for life and health insurance, an applicant's answers are treated as representations, not warranties. A misstatement undoes coverage only if it is material, which is more protective of the insured. A is wrong because an express warranty is guaranteed true and must be contained in the policy, a stricter standard than applies to ordinary application answers. B is wrong because an implied warranty is read into a contract by law, most often in marine insurance, and does not describe written health application answers. C is wrong because a condition precedent is an event that must occur before a duty arises, not the legal character of statements made on an application. When an applicant answers a question falsely on a life or health application, whether that mistake voids the policy depends on one hidden classification. Is a statement a representation or a warranty? A representation is simply what the applicant believes to be true, and it only threatens coverage if it's both false and material. A warranty is a guaranteed, literal promise baked into the contract where even an innocent, immaterial slip can void the policy. Treating answers as representations protects people who misremember dates or round numbers, because only a falsehood significant enough to change the insurer's underwriting decision can undo the policy. Watch for imitators. An express warranty is guaranteed true and written into the policy itself. An implied warranty is read in by law and belongs to marine insurance. And a condition precedent is just an event that must happen before a duty arises. Only representation correctly describes application answers. That forgiveness is exactly what stands between an honest applicant and a voided policy. Question 29. An applicant concealed a serious heart condition but later died in an unrelated car accident. Under the California rule, how is the materiality of that concealment determined? Your options are A. By whether the fact caused death, B. By the size of the death benefit, C. By its probable influence on underwriting, D. By the policy's time in force. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. By its probable influence on underwriting. C is correct because the California Insurance Code determines materiality not by the event but by the probable and reasonable influence of the fact on the insurer's underwriting decision. the heart condition would have influenced that decision. A is wrong because tying materiality to whether the concealed fact caused the death is exactly the test the statute rejects. Materiality is judged not by the event. B is wrong because the size of the death benefit does not measure materiality, which turns on whether the fact would have influenced the insurer's evaluation of the risk. D is wrong because the length of time the policy was enforced does not determine materiality. The focus is the fact's likely effect on the original underwriting decision. California's materiality rule has a striking feature. It doesn't care whether the concealed fact had anything to do with the eventual loss. An applicant hides a heart condition, then dies in an unrelated car accident. The concealment can still be material. Materiality is the hinge on which concealment turns, and California fixes its meaning at underwriting, not at the loss. The test is whether a reasonable insurer, knowing the truth, would have evaluated the risk differently, charged more, added an exclusion, or declined altogether. Insurance is priced on information, so the harm from concealment happens at the moment of pricing, not the moment of loss. When an applicant buries a heart condition, the insurer issues a policy it would have priced differently or declined outright, and that mispricing is the injury. The exam builds traps from tempting but wrong tests, whether the fact caused the death, the size of the death benefit, or how long the policy was in force. None of these control. Only probable influence on the underwriting decision states the rule. The unrelated cause of death does not launder the concealment. California locates the harm at underwriting, so a hidden fact can sink a claim even when it never touched the loss that triggered it. Question 30. Under the California Insurance Code, concealment entitles the injured party to rescind the insurance under which of the following circumstances? Your options are A. Only if the concealment was intentional. B. Whether the concealment was intentional or unintentional. C. Only if a warranty was also breached. D. Only if the loss has already occurred. Which would you go with? Lock it in before the reveal. The correct answer is B. Whether the concealment was intentional or unintentional. B is correct because the California Insurance Code provides that concealment, whether intentional or unintentional, entitles the injured party to rescind. This makes the California rule broader than the common rule in many states. A is wrong because limiting rescission to intentional concealment states the general rule in many other states, but California law expressly reaches unintentional concealment as well. C is wrong because a separate warranty breach is not required. Concealment of a material fact alone is enough to give the injured party the right to rescind. D is wrong because rescission does not depend on a loss having occurred. The right arises from the concealment itself, regardless of whether a claim has been filed. Most states only let an insurer rescind for concealment if the applicant hid a fact on purpose. California is different. It drops the intent requirement entirely. Separate the two possible rules. One requires proof the applicant knowingly hid something, a guilty mind. California's version needs only that a material fact went undisclosed, regardless of intent. Picture two applicants who each leave out a material fact. One does it deliberately. Gambling the insurer won't notice, the other simply forgets. In most states, only the deliberate one is exposed, but in California, both policies are equally vulnerable. The exam tests this with narrower distractors. Limiting rescission to intentional concealment states the majority rule elsewhere, not California's. Requiring a warranty breach or a prior loss is also wrong, since the right to rescind arises from the concealment itself. California strips out the intent requirement, placing the full burden of complete disclosure on the applicant, whether the omission was calculated or innocent. Question 31. The California Insurance Code lists the specifications every insurance policy must contain. Which of the following is not one of those required specifications? Your options are A. The financial rating of the insurer, B. The parties to the contract, C. The period of coverage, D. The risks insured against. Don't overthink it. Which one feels right? The correct answer is A. The financial rating of the insurer. A is correct because the California Insurance Code requires the parties, the property or life insured, the insured's interest if not the absolute owner, the risks, the period and the premium. The insurer's financial rating is not required. B is wrong because the parties between whom the contract is made are specifically required by the statute, making this a mandatory specification. C is wrong because the period during which the insurance continues is one of the 6 listed items, so it must appear and is not the imposter. D is wrong because the risks insured against are expressly listed by the statute, so this item is one of the required specifications rather than the exception. California law requires every insurance policy to contain a specific checklist of terms. Knowing exactly what belongs on that list and what doesn't is the key to this topic. The insurance code names 6 items: the parties, the property or life insured, the insured's interest if not the owner, the risks covered, the period of coverage and the premium. Each one answers a basic question the insured needs settled before signing. The point of the requirement is simple. The essential bargain must live on paper, not in a salesperson's memory or an insurer's private files. Picture the actual policy. It names the parties, identifies the property or life insured, states the interest, lists the risks, sets the period, and gives the premium. The insurer's financial rating never appears because that number describes the company, not the contract. On the exam, the wrong answer is always the one describing the insurer itself, usually the financial rating, while the 6 genuine requirements describe the terms of coverage. Question 32. An insurer markets its policies only through television, mail, and its website, with no producer involved in the sale. This distribution method is known as which of the following? Your options are A. The independent agency system, B. The captive agency system, C. The general agency system, D. Direct response. Got a guess? Lock it in. The correct answer is D. Direct response. D is correct because direct response distribution sells coverage straight to the consumer through media such as mail, television, and the internet, with no producer involved in the transaction. A is wrong because the independent agency system relies on producers who represent several insurers, so a salesperson is clearly involved, unlike direct response. B is wrong because the captive agency system uses producers who represent a single insurer, which still places an agent between the company and the consumer. C is wrong because the general agency system distributes through a general agent who recruits and supports producers, again involving salespeople in the sale. Some insurers sell straight to the consumer with no salesperson anywhere in the transaction. This is direct response distribution, defined by the total absence of a producer. Coverage is advertised on television, offered through the mail, or sold on a website, and the consumer applies directly to the company. No agent takes an application across a kitchen table. Without commissions to intermediaries, insurers can price differently and sell simple, standardized coverage at scale through mass media. Direct response trades the personalized guidance of an agent for volume, convenience, and lower distribution cost. Independent agency uses producers representing several insurers. Captive agency uses producers tied to one insurer. General agency distributes through a general agent who recruits producers. Only direct response removes the producer entirely. On the exam, the signal is coverage sold straight to the consumer through mail, television, or the internet with no producer involved. If any agent appears in the story, it isn't direct response. Question 33. A producer in San Diego tells a client a policy covers a treatment it actually excludes, and the client reasonably relies on that statement. The insurer may be bound under which type of authority? Your options are A. Express authority, B. Fiduciary authority, C. Apparent authority, D. Statutory authority. Which one is it? Pause the video if you need more time. The correct answer is C. Apparent authority. C is correct because apparent authority is the authority a reasonable third party believes an agent holds based on appearances the insurer allowed. When a client reasonably relies, the insurer may be bound even without actual authority. A is wrong because express authority is what the written agency contract actually grants. Misstating coverage is not an authorized act, so this does not explain the binding. B is wrong because fiduciary authority is not a recognized type of agency authority. The relevant categories are express, implied, and apparent authority. D is wrong because statutory authority is not one of the three types of agency authority, which are express, implied, and apparent, so it does not fit the scenario. How can an insurer be bound by a promise its producer was never actually allowed to make? The answer lies in a doctrine called apparent authority. Apparent authority isn't granted by the agency contract at all. It comes from the impression the insurer creates by handing a producer business cards, applications, rate books, and signage that make them look authorized. And when a client reasonably relies on that look, the insurer can be bound. Picture a client who has no way to see the private agency contract. All they see is a producer equipped with the insurer's own forms and appointment. That visible appearance, created entirely by the insurer, is what the client reasonably trusts. Only three genuine types of agency authority exist: express, what the written contract grants, implied, what's reasonably needed to carry out express duties, and apparent, what the insurer's own appearances lead a client to reasonably believe. Fiduciary and statutory authority are not real categories at all. The doctrine places the risk of a producer's overreach on the insurer that created the appearance, not on the client who reasonably trusted it. Reasonable reliance plus a producer's unauthorized promise is the signal for apparent authority. Question 34. The authority explicitly granted to a producer in writing through the agency agreement with the insurer is known as which type of authority? Your options are A. Express authority, B. Implied authority, C. Apparent authority, D. Assumed authority. Take a second. Which answer would you pick? The correct answer is A. Express authority. A is correct because express authority is the authority explicitly spelled out in writing in the producer's agency agreement with the insurer. It defines exactly what the producer is and is not permitted to do. B is wrong because implied authority is not written, but is assumed because it is necessary to carry out the producer's express duties, so it is not granted in words. C is wrong because apparent authority arises from what a reasonable third party believes based on appearances, rather than from an explicit written grant. D is wrong because assumed authority is not one of the three recognized types of agency authority, which are express, implied, and apparent. When an insurer appoints a producer, it hands over a written agency agreement spelling out exactly what that producer may do. The powers named in that document are called express authority. If the agreement says the producer may solicit applications, collect initial premiums, and deliver policies, those stated powers are express authority in its clearest form. It's the written core of the agency relationship, precisely because both sides negotiated and wrote it down. Picture a producer whose contract states they may take health applications and collect the first premium. When the producer does exactly that, the insurer is bound, because it authorized those precise acts in writing, no guesswork required. The exam tests whether you can spot the source of the power. Implied authority is unwritten but necessary to perform express duties. Apparent authority arises from appearances to a third party, and express authority is the written grant itself. Assumed authority isn't a real category at all. Express authority is the bedrock. Authority explicitly granted in words through the agency agreement. Everything else in agency law builds outward from this written core. Question 35. Under the California Insurance Code, an insurance broker transacts insurance on behalf of which party? Your options are A. The insured, B. The insured, C. The insurance commissioner, D. The guarantee association. Before I reveal it, which one do you think is right? The correct answer is B. The insured. B is correct because under the California Insurance Code, a broker transacts on behalf of the insured, but not on behalf of an insurer. The broker represents the client, which distinguishes a broker from an agent. A is wrong because an agent, not a broker, transacts on behalf of the insurer. The defining feature of a broker is that it represents the insured instead. C is wrong because the insurance commissioner regulates the marketplace and does not employ brokers to transact insurance on the commissioner's behalf. D is wrong because the guarantee association protects policyholders of insolvent, admitted insurers and has no role as a principal for whom a broker acts. The single word that defines a broker is loyalty. Under California law, a broker transacts insurance on behalf of the insured, not the insurer, and that one allegiance separates a broker from an agent. An agent represents the insurance company, bound to its interest and appointed to sell its products. A broker is retained by the buyer, shopping the market and advocating for the client. The commissioner and the guarantee association regulate and protect, but neither one employs a broker as its principal. Picture a business owner who hires a broker to find health coverage for employees. The broker surveys policies from several insurers and negotiates on the owner's behalf, but throughout, the broker legally acts for the insured, never for the insurers whose products are under review. The exam loves to reverse the roles or name a regulator as the broker's principal, but naming the insurer, the commissioner, or the guarantee association as who the broker serves is always wrong. Keep this straight. A producer transacting on behalf of the insured is a broker, and that loyalty to the client is what separates a broker from an agent every single time. Question 36. A prospect asks an applicant about obtaining an accident and health solicitor license in California. How should the applicant respond? Your options are: it requires 12 hours of training. B. It is issued only to brokers. C. It must be renewed every 2 years. D. No such license exists in California. What's your answer? Commit to one before I continue. The correct answer is D. No such license exists in California. D is correct because California has no accident and health solicitor license. A solicitor aids only a property and casualty broker agent in lines other than life, disability, or health. So the role does not exist for health coverage. A is wrong because describing training hours assumes the license exists, but there is no accident and health solicitor license to train for in the first place. B is wrong because the solicitor role is limited to property and casualty work and is not an accident and health credential issued to brokers or anyone else. C is wrong because a renewal cycle cannot apply to a license that does not exist. California simply does not recognize an accident and health solicitor. Sometimes the correct answer to a licensing question is that the thing being asked about simply does not exist. There is no accident and health solicitor license in California, and spotting that fact is exactly what the exam is testing. The confusion works because solicitor is a genuine California license, but a solicitor only assists a property and casualty broker agent in lines other than life, disability, or health. There is no equivalent solicitor role on the life and health side, so pairing accident and health with solicitor invents a credential that was never made. California's licensing structure defines each credential with a specific scope: life agents, accident and health agents, property broker agents, casualty broker agents, and the solicitor tied only to property and casualty. When a question invents a hybrid outside the structure, the truthful answer is that it simply doesn't exist. The exam dresses up the trap with realistic specifics: a choice naming training hours, a choice limiting who may hold it, and a choice describing a renewal cycle, or quietly assume the license is real. Only recognizing that no such license exists cuts through the setup. Remember, the solicitor license belongs strictly to property and casualty support work. Any accident and health version of it is a fiction the exam plants to see who takes the bait. Question 37. Under the California Insurance Code, the accident and health or sickness agent license authorizes the licensee to transact coverage for which of the following? Your options are A. Real and personal property, B. Automobile liability, C. Sickness, bodily injury, or accidental death, D. Workers' compensation only. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Sickness, bodily injury, or accidental death. C is correct because the accident and health or sickness license authorizes coverage for sickness, bodily injury, or accidental death, and may include disability income benefits. It does not extend to property or casualty lines. A is wrong because real and personal property coverage falls under a property license, not the accident and health license, which is built around sickness and injury. B is wrong because automobile liability is a casualty line requiring a separate license. The accident and health agent has no authority to transact it. D is wrong because the license is not limited to workers' compensation. It broadly covers sickness, bodily injury, and accidental death for individuals. Let's clarify exactly what a California accident and health or sickness agent license covers, and just as importantly, what it doesn't. The license authorizes coverage triggered by sickness, bodily injury, or accidental death, and it commonly extends to disability income, which replaces earnings lost to a disabling illness or injury. California deliberately divides insurance authority by line of business, because health and disability coverage involves its own body of knowledge and its own consumer protections, distinct from insuring buildings or cars. Picture the agent helping a client with health, disability, and accidental death coverage all within their license. But if that same client needs a van or warehouse insured, the agent must decline, since that requires property or casualty authority. Property coverage belongs to a property license. Automobile liability requires a casualty license, and workers' compensation alone is too narrow to describe this broader credential. The line is simple: harm to the person is in, property and third-party liability are out. Question 38. Under the California Insurance Code definition of transact, which of the following activities, standing alone, requires an insurance license? Your options are A. Solicitation of insurance, B. Printing a company brochure, C. Designing a policy form, D. Auditing an insurer's reserves. Which would you go with? Lock it in before the reveal. The correct answer is A. Solicitation of insurance. A is correct because the California definition of transact includes solicitation, negotiation, execution, and servicing of insurance. Because solicitation alone counts as transacting, it requires a license even without completing a sale. B is wrong because merely printing a brochure is a production task, not solicitation, negotiation, execution, or servicing. So by itself, it is not transacting insurance. C is wrong because designing a policy form is an internal drafting function, rather than one of the 4 activities the statute defines as transacting. D is wrong because auditing an insurer's reserves is a financial review function, not solicitation or any other listed transacting activity requiring a producer license. Why does a license matter at all? Because California defines transacting insurance far more broadly than most people expect, and understanding that definition is the key to this whole topic. The California Insurance Code lists 4 activities that count as transacting: solicitation, negotiation, execution of a contract, and servicing that contract. Because the definition is written in the disjunctive, doing just one of these 4 is enough to require a license. This broad definition exists to close a gap. If only signing a contract counted, someone could solicit business and steer people toward coverage while claiming they never transacted insurance. So California makes solicitation itself a licensed activity. Picture someone who only approaches prospects and urges them toward a plan, then hands them off to finish the deal. No contract is signed and no terms are negotiated. Yet California still treats this as transacting insurance because soliciting alone is one of the 4 acts. On the exam, only solicitation is one of the 4 defining acts: printing brochures, designing policy forms, and auditing reserves are support or internal functions, not transacting, which is why solicitation alone requires a license. Question 39. Under the California Insurance Code, a person who transacts insurance without a valid license is guilty of which of the following? Your options are A. A felony with mandatory prison. B. A licensing fee surcharge only. C. A civil violation with no criminal penalty. D. A misdemeanor with fine, jail, or both. Don't overthink it, which one feels right. The correct answer is D. A misdemeanor with fine, jail, or both. D is correct because under the California Insurance Code, transacting insurance without a valid license is a misdemeanor, punishable by a fine of up to $50,000, up to 1 year in county jail, or both. A is wrong because the offense is classified as a misdemeanor, not a felony, and it does not carry a mandatory prison sentence under the statute. B is wrong because the consequence is a criminal penalty, not merely a fee surcharge, reflecting how seriously the code treats unlicensed activity. C is wrong because transacting without a license is more than a civil matter. It is a criminal misdemeanor that can include jail time as well as a fine. California doesn't treat unlicensed insurance transacting as a paperwork slip-up. It backs its licensing requirement with real criminal consequences, and understanding why reveals a classic exam trap. Transacting insurance without a valid license is a misdemeanor, punishable by a fine up to $50,000, up to a year in county jail, or both. That combination of real money and real jail time shows how seriously the state treats the offense. The penalty exists because licensing protects the public, ensuring people transacting insurance are qualified, honest, and accountable. Without meaningful punishment, the incentive to skip education, exams, and oversight would be far too strong. Exam choices push the offense too high, calling it a felony with mandatory prison, or too low, calling it a fee surcharge or a purely civil matter. Only one answer is correct: a misdemeanor punishable by a fine, jail, or both. Keep this straight. California classifies unlicensed transacting as a misdemeanor, with a fine reaching $50,000 and up to a year in jail. That's exactly why licensing is never optional. Question 40. A producer in Sacramento deposits client premiums into the producer's personal checking account for a few days before remitting them. This handling of trust funds is known as which of the following? Your options are A. Coinsurance, B. Commingling, C. Subrogation, D. Rebating. Got a guess? Lock it in. The correct answer is B. Commingling. B is correct because premiums are held by a producer in a fiduciary capacity and must be kept separate from personal funds. Mixing them with the producer's own money is commingling, which the code prohibits. A is wrong because coinsurance is a cost-sharing arrangement between insurer and insured on a claim, not the improper mixing of premium with personal funds. C is wrong because subrogation is an insurer's right to recover from a responsible third party after paying a loss, unrelated to how premium is held. D is wrong because rebating is giving a client something of value not stated in the policy as an inducement to buy, a different prohibited practice from mixing funds. Money a producer collects from a client is never truly theirs. Premiums are held in trust on their way to the insurer, and the law demands they stay separate from the producer's personal funds. Once client premiums sit in a personal account, they become exposed to the producer's own creditors. They can be spent by accident or design, and the clean line between whose money is whose disappears. Keeping funds in a dedicated trust account preserves that line and removes both temptation and opportunity. Commingling is a violation regardless of intent or eventual outcome. A producer who fully intends to forward every dollar, and does, has still committed the violation the instant personal and client funds touch, because the mixing itself strips the funds of their protected status. The exam surrounds commingling with lookalikes. Coinsurance is cost-sharing between insurer and insured on a claim. Subrogation is the insurer's right to recover from a responsible third party. Rebating is an unlawful inducement to buy. Only commingling names the improper mixing of premium with personal funds. Premiums are held in trust, and commingling is the failure to keep that trust money separate, committed the moment personal and client funds are allowed to mix. Question 41. A producer carries errors and omissions insurance. Which of the following situations would generally fall outside the protection that coverage provides? Your options are A. Negligently failing to submit an application, B. Accidentally misstating a policy benefit, C. Intentionally defrauding a client of premium, D. Overlooking a needed coverage recommendation. Which one is it? Pause the video if you need more time. The correct answer is C. Intentionally defrauding a client of premium. C is correct because errors and omissions insurance covers negligence and honest mistakes in professional duties. It does not cover intentional, fraudulent, or criminal acts, so deliberately defrauding a client of premium is excluded. A is wrong because negligently failing to submit an application is an honest professional mistake, exactly the kind of error the coverage is designed to address. B is wrong because accidentally misstating a benefit is an unintentional error in professional service, which generally falls within errors and omissions protection. D is wrong because overlooking a needed coverage recommendation is a negligent oversight in professional work, the type of claim errors and omissions coverage responds to. Errors and omissions insurance protects producers against claims of honest mistakes, but it draws a hard line at deliberate wrongdoing. Understanding that line is the key to mastering this topic. Competent professionals still cause harm through ordinary human error, missed deadlines, clerical slips, good faith but mistaken recommendations, or forgetting to submit an application. E&O coverage lets a producer work without the constant fear that one honest slip will be financially ruinous. much like malpractice insurance for other professions. Negligence is a failure to exercise reasonable care, where the harm was never meant to happen. Intentional misconduct is chosen, with the harm as the goal or a knowing result. Covering fraud would let wrongdoers offload the cost of their own crimes onto an insurer, so policies exclude intentional, fraudulent, and criminal acts. Picture a producer who carelessly forgets to submit an application and a client suffers a loss. That claim is covered because the failure was negligent. Now, picture a producer who simply pockets the premium and never buys the policy at all. That is fraud, and no E&O policy will touch it. On the exam, watch for the one option describing intentional, fraudulent, or criminal conduct, like defrauding a client of premium, since that's what falls outside the coverage. Everything negligent, accidental, or careless stays within it. Question 42. Under the California Insurance Code, an insurer that is entitled to transact insurance in California, having complied with the conditions the law imposes, is described as which of the following? Your options are A. Admitted, B. Alien, C. Domestic, D. Reciprocal. Take a second. Which answer would you pick? The correct answer is A. Admitted. A is correct because an admitted insurer is one entitled to transact insurance in California, having met the conditions the law imposes. An admitted insurer holds a certificate of authority and is also called authorized. B is wrong because alien describes an insurer's place of origin, specifically organization in another country, not whether it is authorized to operate in California. C is wrong because domestic refers to an insurer organized under California law, which concerns origin rather than the authority to transact business. D is wrong because reciprocal names a form of insurer ownership in which members insure one another, not the status of being authorized to transact. Let's dig into what it really means for an insurer to be admitted in California. An admitted insurer has earned California's permission to sell coverage, having met the conditions the law requires. It holds a certificate of authority from the Department of Insurance and is also called an authorized insurer, remaining subject to the state's ongoing supervision. Picture a company applying to the Department of Insurance, proving its financial strength, and satisfying the statutory conditions. Once it receives its certificate of authority, it becomes an admitted insurer, authorized to transact business and regulated going forward. The exam loves to mix these up, so keep the axes separate. Alien and domestic describe where an insurer was organized. Reciprocal describes an ownership structure. And only admitted or authorized describes permission to transact in California. Admitted status matters to policyholders too, since it ties the insurer into the state's guarantee association safety net if it becomes insolvent. Keep this straight. Admission is about authorization, a separate question from where an insurer came from or how it's owned. Question 43. An insurer organized under the laws of a country other than the United States and doing business in California is classified as which of the following? Your options are A. domestic insurer, B. a foreign insurer, C. a fraternal insurer, D. an alien insurer. Before I reveal it, which one do you think is right? The correct answer is D. An alien insurer. D is correct because an alien insurer is one organized under the laws of a country other than the United States. The origin axis classifies insurers as domestic, foreign, or alien based on where they were organized. A is wrong because a domestic insurer is organized under the laws of California itself, not under the laws of a foreign country. B is wrong because a foreign insurer is organized under the laws of another United States state, whereas this insurer comes from another country entirely. C is wrong because fraternal describes a membership ownership structure organized under a lodge system, not the country in which an insurer is organized. Insurers are classified by where they were organized, and that single question sorts every company into one of three categories. A domestic insurer is chartered in the state itself. A foreign insurer is chartered in another US state. An alien insurer is chartered in another country entirely. Together, these three cover every possibility. The labels only make sense from the viewpoint of the state where the insurer does business. The very same company can be domestic in its home state and foreign everywhere else in the country. Picture an insurer chartered in Europe that sells policies in California. It's domestic back home, but in California it's alien, because its organizing jurisdiction sits outside the United States entirely. Domestic, foreign, and alien all track where an insurer was organized, not how it's owned or where it's licensed. Alien is simply the one that crosses the national border. Question 44. The California Life and Health Insurance Guarantee Association protects policyholders when an insurer becomes insolvent. Coverage from which type of insurer is generally not protected by the association? Your options are A. An admitted stock insurer, B. An admitted mutual insurer, C. A non-admitted surplus line insurer, D. An admitted fraternal insurer. What's your answer? Commit to one before I continue. The correct answer is C. A non-admitted surplus line insurer. C is correct because the Guarantee Association protects policyholders of insolvent, admitted life and health insurers up to statutory limits. Coverage placed with a non-admitted surplus line insurer is not protected by the association. A is wrong because an admitted stock insurer is authorized in California, so its policyholders fall within the Guarantee Association's protection if it becomes insolvent. B is wrong because an admitted mutual insurer is likewise authorized and a member of the association, meaning its policyholders are covered up to the statutory limits. D is wrong because an admitted fraternal insurer is authorized in the state, so its insureds also receive Guarantee Association protection in an insolvency. When an insurer fails, policyholders risk being left with worthless promises. California's Life and Health Insurance Guarantee Association exists to prevent that, but its protection has a crucial limit. The system works like a mutual backstop. Authorized, admitted insurers pay assessments into the association, so if one of them collapses, the others collectively cover its policyholders' claims up to statutory limits. Only admitted insurers pay into the association and only their policyholders are protected. A non-admitted surplus line insurer sits entirely outside this framework, so it neither contributes nor receives coverage. Admitted stock, mutual and fraternal insurers are all authorized in California, so their policyholders fall within the association's protection. Only the non-admitted surplus line insurer stands outside the pool that funds the guarantee. The trade-off for surplus lines accepting unusual risks is losing Guarantee Association protection. If insolvency strikes, only admitted insurers' policyholders have a safety net to rely on. Question 45. A mutual insurer returns part of its divisible surplus to the policy owners who own the company. These distributions are issued on participating policies and are generally treated in what way for tax purposes? Your options are A. As fully taxable interest income, B. As a non-taxable return of premium, C. As a taxable capital gain, D. As taxable wages to the insured. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B. As a non-taxable return of premium. B is correct because a mutual insurer issues participating policies and pays policy dividends from divisible surplus. Because these dividends are considered a return of overpaid premium, they are generally not taxable to the policy owner. A is wrong because the dividends are treated as a return of premium rather than interest income, so they are not taxed as fully taxable interest. C is wrong because policy dividends are not a capital gain. They represent premium the policy owner overpaid and is receiving back, which is not a taxable gain. D is wrong because the distributions are not compensation for services, so they are not taxable wages. They are a return of the policy owner's own premium. Mutual insurers are owned by their policy holders, not outside investors, and that changes how their dividends are taxed. When surplus remains after claims and expenses, the insurer returns part of it to policy owners as a policy dividend. Insurers deliberately overcharge premiums as a cushion for safety, and when the year goes better than expected, that extra money comes back to you. Since it's simply your own overpayment returned, it isn't income, a gain or compensation, so it isn't taxed. The exam tempts you to call the dividend taxable interest income, a capital gain, or wages, but each of these wrongly treats a refund as earnings. The only correct characterization is a non-taxable return of premium. The word dividend is misleading, because a stock dividend paid to an investor is taxable profits, while a policy dividend paid to a policy owner is just a refund of their own premium. The name is the same, but the underlying nature is completely different. Whenever you see a mutual insurer paying dividends on participating policies, remember the payment is overpaid premium coming home, not earnings, gains, or wages. Question 46. Within an insurance company, the division that uses statistics and the law of large numbers to calculate premium rates and set reserves is which of the following? Your options are A. The claims division, B. The marketing division, C. The underwriting division, D. The actuarial division. Which would you go with? Lock it in before the reveal. The correct answer is D, the actuarial division. D is correct because the actuarial division uses statistics and the law of large numbers to calculate premium rates and establish reserves, pricing the product soundly so the insurer can meet its obligations. A is wrong because the claims division investigates, evaluates, and pays or denies losses after they occur, rather than calculating rates and reserves in advance. B is wrong because the marketing division designs distribution and brings in business. It does not perform the statistical rate-setting work of the actuaries. C is wrong because the underwriting division evaluates and classifies individual risks, but pricing the product overall and setting reserves is the actuarial function. Somewhere inside every insurer, a team turns the mathematics of risk into the price on a policy. That's the actuarial division, the function that uses statistics and the law of large numbers to calculate premium rates and set reserves. Sound pricing is the difference between an insurer that survives and one that collapses. Charge too little and claims outrun premiums. Charge too much and competitors win the business. Actuaries thread that needle using loss statistics, mortality and morbidity tables, and the predictive power of large pools, and they calculate the reserves that back the company's promises. The exam separates actuarial from three other functions. Claims investigates and pays losses case by case after they occur. Marketing designs distribution and brings in business. Underwriting evaluates and classifies individual applicants. Only actuarial calculates premium rates and reserves using statistics and the law of large numbers. Picture an insurer launching a new health product. Before a single policy is sold, actuaries study expected claims across the pool, build the rate structure, and set the reserves the company must hold. Work that happens at the level of the whole book of business, not any single applicant or claim. The signal word is statistics and the law of large numbers used to calculate premium rates and reserves. That's always the actuarial division, the quantitative backbone that keeps the whole enterprise solvent. Question 47. In California, how does a person become the insurance commissioner who heads the Department of Insurance? Your options are A. The person is elected by the people. B. The governor appoints the person. C. The legislature selects the person. D. Insurers vote the person into office. Don't overthink it. Which one feels right? The correct answer is A. The person is elected by the people. A is correct because California's insurance commissioner is elected by the people at the same time and in the same manner as the governor for no more than 2 4-year terms. The commissioner enforces the insurance code. B is wrong because the commissioner is not appointed by the governor in California. The office is filled by a statewide vote of the people. C is wrong because the legislature does not select the commissioner. The position is an elected one decided directly by California voters. D is wrong because insurers do not vote the commissioner into office. Allowing the regulated industry to choose its regulator would defeat the office's purpose. California made a deliberate choice about who regulates insurance and how they get the job. The insurance commissioner is elected by the people, on the same ballot and in the same manner as the governor, for a limit of 2 4-year terms. An insurance regulator holds enormous power over an industry that touches nearly every resident, approving practices, disciplining licensees, and protecting consumers. Making the office elective means the commissioner answers directly to voters, not to a governor or the industry being regulated. Picture a statewide election where, on the same ballot that decides the governor, voters also choose the insurance commissioner. The winner runs the Department of Insurance, enforces the insurance code, and remains independent of the governor, accountable only to the voters who elected them. The exam tests this by offering common alternatives: appointment by the governor, selection by the legislature, or insurers voting the commissioner into office, which would let the regulated industry pick its own regulator. Only election by the people describes California's actual system. Remember that California elects its insurance commissioner on the governor's ballot, limited to 2 4-year terms, a structure built to keep the regulator accountable to the public and independent of both the executive branch and the companies it regulates. Question 48. The California Unfair Practice Act prohibits acts such as twisting and false advertising in the business of insurance. Who has authority to enforce the act? Your options are any consumer through a private lawsuit. B. The Federal Department of Insurance. C. Only the insurance commissioner. D. The county district attorney alone. Got a guess? Lock it in. The correct answer is C. Only the insurance commissioner. C is correct because the Unfair Practices Act is enforced only by the insurance commissioner through cease and desist orders and monetary penalties. The Act does not create a private right of action for a consumer to sue under it. A is wrong because the Act does not give consumers a private right of action. Enforcement rests with the commissioner rather than with individual lawsuits under the Act. B is wrong because there is no Federal Department of Insurance enforcing the state statute. Insurance is regulated at the state level by the commissioner. D is wrong because the district attorney does not enforce the Unfair Practices Act. That authority is vested specifically in the insurance commissioner. The California Unfair Practices Act bans things like twisting and false advertising in insurance. But the exam really wants to know who gets to enforce those bans. Enforcement rests solely with the insurance commissioner, who investigates violations, issues cease and desist orders, and imposes monetary penalties. Critically, the Act gives consumers no private right of action to sue under it themselves. Picture a producer twisting policies using misrepresentation to churn a client from one policy to another. Only the commissioner can step in, investigate, and stop it. The exam tricks people by offering enforcers the Act never empowers. a private consumer lawsuit, a federal department, or the district attorney. None of these hold authority. Insurance is regulated at the state level, and only the commissioner enforces the statute. California deliberately concentrates enforcement in the commissioner's hands through cease and desist orders and penalties, and just as deliberately withholds a private right to sue. Question 49. Under the Fair Claim Settlement Practices Regulations, when an insurer denies a claim in whole or in part, the denial must take which of the following forms? Your options are: A. An oral explanation by phone is sufficient. B. No explanation is required. C. A note in the claim file. D. A written denial stating the specific reasons. Which one is it? Pause the video if you need more time. The correct answer is D. A written denial stating the specific reasons. D is correct because the Fair Claim Settlement Practices Regulations require that a denial be in writing and state the specific reasons, including the policy provisions relied upon, so the claimant is not left guessing why a claim was denied. A is wrong because an oral explanation does not satisfy the regulation, which requires the denial to be communicated to the claimant in writing. B is wrong because the rules expressly require reasons for a denial, so providing no explanation would itself violate the fair claim standards. C is wrong because documenting the file internally is not enough. The claimant must receive a written denial that states the specific grounds for the decision. California doesn't leave claim denials to an insurer's discretion. Under the Fair Claim Settlement Practices Regulations, a denial must be written and must state the specific reasons, including the policy provisions relied upon. This rule exists because claims handling is where the insurance promise is truly tested, and a claimant is often in no position to judge whether a denial is fair. A written, specific denial forces the insurer to justify itself and gives the claimant real power to push back. The requirement splits into form and content. The denial must be written, not just spoken, and it must specifically state the actual reasons and the policy provisions relied upon. Both pieces are required together. The exam tests this by offering weaker forms of denial, an oral explanation by phone, no explanation at all, or a note buried in the internal claim file. Each one fails because none delivers a written specific denial directly to the claimant. California requires every claim denial to be delivered in writing with specific, provision-based reasons, so the claimant always knows exactly why the claim was denied. Question 50. In a reinsurance arrangement, the insurer that issued the original policy and transfers part of its risk to another insurer is known as which of the following? Your options are: A. The excess insurer, B. The ceding company, C. The retrocessionaire, D. The guarantee association. Take a second. Which answer would you pick? The correct answer is B. The ceding company. B is correct because the ceding company, also called the primary or direct insurer, issued the original policy and transfers part of its risk to a reinsurer. It remains responsible to the original insured. A is wrong because excess insurer describes a layer of coverage above a primary limit, not the company that cedes risk in a reinsurance transaction. C is wrong because a retrocessionaire accepts risk that a reinsurer itself passes along, which is a further step removed from the original ceding insurer. D is wrong because the guarantee association is a state safety net for insolvent admitted insurers, not a party that assumes ceded risk through reinsurance. Insurers buy insurance too. When a company that issued policies wants to limit its exposure, it transfers part of its risk to another insurer through reinsurance, and the insurer handing off that risk is called the ceding company. The word ceding captures the action. the company hands off a portion of the risk it accepted from its own policyholders, so no single insurer bears the full weight of the risks it has assumed. Reinsurance does not change the primary insurer's obligation to its own policyholders. If a claim arises, the original insured looks to the ceding company, which pays and then recovers the reinsured portion from its reinsurer. An excess insurer covers a layer above a primary limit, not a party transferring risk in reinsurance. A retrocessionaire accepts risk. A reinsurer itself passes along one step further down the chain. The Guarantee Association is a state safety net for insolvent insurers, not part of a reinsurance deal. The ceding company is the primary insurer that transfers part of its risk to a reinsurer, and it remains fully responsible to its own policyholders no matter how much risk it reinsures. That wraps up our California Life, Accidents and Sickness Q&A session for today. If you'd like more practice covering everything we just went over, head on over to our website. You'll find the link right down in the description below. Once you're there, you'll find hundreds of free practice questions plus complete study guides, all ready for you to use whenever you need them. Subscribe to catch the next part, and good luck on your exam.